My name is Jane Collins, and I'm the Enforcement Team Leader for Access and Benefit Sharing within the Office for Product Safety and Standards. The aim of this webinar today is really to raise awareness of access and benefit sharing in general, but specifically to help you understand how to comply with the UK ABS regulation and to ask us any questions that you might have. So if you have any questions throughout the session that you'd like us to answer, please enter them into the Q&A chat function, which you should be able to see on the right-hand side of your screen, and we'll aim to get through as many of those as we can. If you have a similar question to one that's already been posted, I'm not sure if the option is available, but you may be able to upvote the question by clicking the like button. And we'll prioritise those if we're short on time. But in any event, please do or put your questions there, and then we'll take a look towards the end. We'll also have some time at the end of the presentation for people to unmute themselves and to ask questions if you would like to do so. Just so that you're all aware, this session is being recorded, and the recording will be shared as soon as possible following this event, and the PowerPoint slides will also be shared with you too. Could we have the presentation now, please, on the screen? It's possible to share it. Brilliant, thank you. Great, okay, so I will now hand over to my colleague Frances to introduce herself and to start the presentation.
Thanks, Jane. Good morning, everyone. I'm Frances. I'm a compliance officer in OPSS working under Jane on access and benefit sharing legislation. So I'm going to start this presentation by giving you a brief introduction to the government departments that are responsible for access and benefit sharing in the UK. Next, I'll give an overview of the obligations that users must comply with under the UK ABS regulation before passing back to Jane. She's going to describe our approach towards supporting and enforcing compliance in the UK, and then discuss some of the frequent questions and challenges raised by users of genetic resources, which may be useful for you all to be aware of. And finally, as Jane said, we'll take some time at the end of the presentation to go through and answer any questions or scenarios that you may have. So next slide, please. So the ABS team in the UK, oh sorry, the next one. Thank you. So the ABS team in the UK is spread across two government departments. The first being DEFRA, that's the Department for Environment, Food and Rural Affairs. And the second being the Office for Product Safety and Standards, that's OPSS, as Jane mentioned, which sits within BEIS, the Department for Business, Energy and Industrial Strategy. DEFRA acts as the policy lead for legislation related to ABS in the UK, and they have the national focal point, Keith Barber, who is the main contact person for any policy questions related to ABS in the UK. So Jane and I work for OPSS, which acts as the competent national authority for ABS in the UK. Our role focuses on the implementation and enforcement of ABS legislation. OPSS has experience in other technical and product-based regulation with an environmental focus, such as the timber regulations, eco-design and alternative fuels. So, in a nutshell, DEFRA are the people to go to if you have questions related to policy, and we at OPSS are here to support compliance and enforce the regulation. Next slide, please. Thank you. So, when it comes to determining whether a particular project with genetic resources falls within scope of the UK ABS regulations or not, there are four scope elements that you need to think about: geographic, temporal, material, and utilisation. So if we start with geographic scope, users need to identify the country where the genetic resource originates, and then determine whether the country is a party to the Nagoya Protocol and whether they have applicable access legislation in place. If the country is a party and has ABS measures in place, then the genetic resource may be in scope. In terms of temporal scope, only genetic resources accessed on or after the 12th of October 2015 may be in scope. With regards to material scope, only non-human genetic materials that contain functional units of heredity, genes, e.g. plants, animals, microorganisms, as well as any traditional knowledge associated with those genetic resources may be in scope, unless and I think this may be applicable to some people here, unless they are already covered by a specialised international ABS instrument, for example, the Pandemic Influenza Preparedness Framework, which is under the World Health Organization, or the International Treaty for Plant Genetic Resources for Food and Agriculture, which is under the Food and Agricultural Organization. And in addition, any derivatives of genetic resources may also be in scope when accessed with the genetic resource. And lastly, there's the utilisation scope. This means that work may be in scope if research and development is conducted into the genetic and/or biochemical composition of a genetic resource, including through the application of biotechnology. And it's also important to note that the UK ABS compliance measures only apply to utilisation of genetic resources taking place within the UK. And I just want to emphasise that it's really important that all of these scope conditions, they must be fulfilled for a project to be considered within scope of the UK ABS regulations. If you meet 3 of these criteria but not the 4th, then your project is not in scope. It must really be all 4. Okay, next slide, please. Thank you. So the UK ABS regulation and aspects we just looked through surrounding scope are currently in force in the UK, but it's important that UK users of genetic resources always make sure to seek and comply with the ABS laws in the provider country. So there can be cases where users are out of scope of our UK compliance measures, but at the same time there are ABS laws in the provider country that users will need to comply with. For example, there are national access measures in place in Australia that users will need to follow, but Australia is not a party to the Nagoya Protocol, and therefore genetic resources from Australia fall out of scope of UK compliance measures. This means that although UK users will need to comply with Australian national access laws, we are unable to enforce compliance with those laws here in the UK. Okay, next slide, please. Thank you. So now we will discuss the practical aspects. What do you, as users in the UK, actually have to do in order to comply? So what are the obligations that users of genetic resources need to be aware of? There are 4 main aspects. The first obligation is to exercise due diligence. That is to make sure that the genetic resources which users intend to utilise are accessed in accordance with the applicable access and benefit sharing legislation or regulatory requirements of the provider countries. 2. Seek and keep all relevant correspondence and documentation for a minimum of 20 years after research and development has ended, and then transfer that evidence to any subsequent users. 3. Submit a due diligence declaration at the stage of receiving research funding. And 4. Submit a due diligence declaration at the stage of final product development. So, if we think about the very beginning of a research project, when a researcher identifies a genetic resource that they want to access, the first step will be to exercise due diligence. And a good place to start your due diligence is the Access and Benefit Sharing Clearinghouse website. So if we could have the next slide, thank you. So this is the homepage of the Access and Benefit Sharing Clearinghouse website. And here you can check the provider country's profile, which will tell you whether the country is a party to the Nagoya Protocol, and it can also have information on whether applicable national ABS laws are in place. And this slide just shows you a screenshot of the countries that are a party to the Nagoya Protocol in purple. And you can use the link at the bottom of this slide if you want to go and have a look at the website and you haven't yet. So if I could have the next slide, please. Thank you. So, for an example, if you were interested in accessing genetic resources from Kenya, you could visit the country's profile on the ABS Clearinghouse, which looks like this. And here we can see that Kenya is a party to the Nagoya Protocol. And if we look under the Legislative, Administrative or Policy Measures tab, we can see that Kenya does indeed have national access measures in place. And you can sometimes find more up-to-date information under the Interim National Reports tab at the bottom of the screen, and also by looking at the national websites of the provider countries. However, if the information is still not clear and you are still unsure how to comply, we suggest contacting their national focal point, which there should be details here on the Access and Benefit Sharing Clearinghouse website. So next slide, please. Thank you. So what does all this actually mean for users? To start, a user will identify a genetic resource they want to access, and the first step in compliance is to exercise due diligence to ensure that genetic resources are accessed in a legal manner from the country of origin. The user will need to check whether the provider country is a party to the protocol and whether they have access measures in place as we described. And from here, there are 2 main routes. If the provider country in question is not a party and has no access measures in place, a user can go ahead and access the desired genetic resources. Alternatively, if the country is a party to the protocol and also has access measures in place, in this case, the user will have to follow the requirements of the provider country, and that will usually involve getting permission from the relevant authorities in the provider country in the form of a permit and negotiated terms and conditions in the form of a contract. The provider country may then upload these documents to the ABS clearinghouse that we've just looked at to create an IRCC, an internationally recognised certificate of compliance. All of this information should be kept for 20 years and then transferred to any subsequent users of the genetic resource. Next slide, please. Thank you. So Article 4 of the UK ABS regulation describes the obligations of users of genetic resources in order to comply, which is summarised on this slide. An internationally recognised certificate of compliance, or IRCC, which includes content of the mutually agreed terms, which can be used as evidence of compliance. However, these certificates are optional documents for the provider country to upload to the clearinghouse. If an IRCC is not available to a user, they should ensure that they have evidence to support the date, place of access, description of the genetic resource and/or associated traditional knowledge, the source of the genetic resources, and any subsequent users. If applicable, users should also obtain evidence of any rights and obligations, access permits, and mutually agreed terms. And it is a legal requirement to seek, keep, and transfer these documents to any subsequent users. Next slide, please. Thank you. So now let's take a look at the research and development stages taking place after the researcher has obtained the genetic resource. So benefits such as data, technology, in-country training or financial benefits may be shared at various stages along the research and development value chain. And there are two specific stages in the value chain where users working in the UK are required to submit due diligence declarations, which, as we've mentioned, the first is after receiving research funding and the second is before placing a product on the market. Next slide, please. Thank you. And I'm just going to briefly talk about two optional mechanisms that organisations can use to gain recognition for the ABS procedures that they've adopted and which support ABS compliance. And these are best practices and registered collections. Best practices are the procedures, rules or mechanisms that are developed and overseen by associations of users or other interested parties, which help to ensure compliance with the ABS regulation when implemented. A registered collection refers to a collection which has demonstrated the capacity to apply standardised procedures for exchanging samples of genetic resources and related information. And this involves supplying genetic resources and related information to third persons with evidence to prove that the genetic resources have been accessed in accordance with applicable ABS legislation, thereby providing legal certainty. Okay, I'm now going to pass over to Jane to talk you through the rest of the slides.
Thanks, Francis. So if we could please move to the next slide. So I'm going to take you through the rest of the presentation. I'll briefly talk to you now about what's happened in the UK with regards to access and benefit sharing as a result of the end of the EU exit transition period. I'll then talk to you about our approach towards enforcing the UK ABS regulation, some of the challenges that we have noticed that users potentially experience, and some questions which have been submitted as part of the registration process. So as you're aware, the transition period came to an end on the 31st of December last year. So you may be wondering, if you're not aware, of what exactly that meant for the UK ABS regulation that we are enforcing. So the main point here really is that the UK remains a party to the Nagoya Protocol, and current user obligations remain the same as they did before. There are, as Francis alluded to just now, there are new processes in place for those of you who wish to submit due diligence declarations, or if you would be interested in applying for best practice or registered collection status, but the requirements for those are the same as previously. The EU best practices, or the best practices and registered collections which were recognised in the EU or are recognised in the EU, are no longer recognised here in the UK. But as I said, if you wish to register a collection or a best practice or to submit a due diligence declaration, you're welcome to do that, and you will find more information about exactly what steps to take by taking a look at our OPSS webpage. I'll add a link, or there is a link at on the last slide of this presentation, which will take you directly to that information. So particularly for due diligence declarations and best practices, or actually the registered collection, not the best practice, there is a form that you can fill in, and then you will be able to send that to the email address which is noted on our webpage. Next slide, please. So the way that we enforce the ABS regulation in the UK is in line with what's known as the Regulator's Code. And that means essentially that we support compliance and growth, we engage with those that we regulate, we base all of our activity on risk, we share information, we offer clear guidance, and we are transparent. Next slide. So when we do find an incident of non-compliance at OPSS, we do have a number of powers that we can use. So we always educate those that we work with. We try to raise awareness and ensure that everyone who's affected understands their obligations and the requirements of the regulation. And here on this slide, we've described the powers that we at OPSS have in relation to the sanctions. So we can offer advice and guidance, we can accept enforcement undertakings, we can also issue warning letters, compliance or stop notices, variable monetary penalties, or in the cases of very severe non-compliance, we can take court action. We are legally required to publish all of our sanctions, which is something that you should be aware of because that can have potentially reputational repercussions. But just to emphasize that we do always start with education and advice and guidance wherever possible, and further actions will depend on the severity of any non-compliance. Next slide, please. So since 2014, the ABS team within OPSS have focused largely on raising awareness of the ABS regulation, helping organisations to determine whether their work is in scope or not, and also how to comply. This is something that we will be continuing with. Of course, it's an important component of our work, and we strive to do that via workshops, articles, blog posts, and also webinars such as this one. But our approach within OPSS towards working with this regulation is evolving, and we are now shifting our focus slightly more towards the enforcement of the regulation, as we have been doing so for the last few years. Next slide, please. So you may now be wondering, what actually does our enforcement activity look like? So as I mentioned, this is something that we are already doing. We do already conduct audits with organisations to analyse compliance with the ABS regulation. And we start the process by identifying projects with potential to be in scope of the regulation using publicly available information. We then get in touch with organisations and require a list of projects that the organisation is responsible for, which involves genetic resources. Once we have that list, we take a look, we then select a few projects and get in touch with the organisation and require evidence associated with those specific projects to demonstrate due diligence with the ABS regulation. And if necessary, we can also provide feedback on a case-by-case basis. At the moment, we're focusing on organisations in receipt of grant funding, but we will be expanding in the next few months to other market sectors. Next slide, please. So I thought this would be a good opportunity just to touch on due diligence. It's a phrase that you've no doubt heard throughout this presentation so far, and it's something that we find is not always perhaps the most clear to users of genetic resources, so it's worth spending a bit of time on. So due diligence can be thought of as the thoroughness and best possible efforts to determine whether a genetic resource and or associated traditional knowledge has been accessed legally. When we're looking at evidence of due diligence, we're really looking for evidence that the user has available to prove or to indicate the judgments and decisions that they've made. We also consider that greater care with regards to due diligence should be taken for more risky activities. And it's also important that evidence is associated with staying up to date with relevant information, particularly in cases where situations are unclear or may change. Next slide, please. So when it comes to thinking about evidence of due diligence, there are two sort of main categories that we can think about here. It may be that you have evidence to prove compliance when a project is in scope of the regulation, or it may be that your project is considered out of scope, and that will be another category of evidence. So if your project is in scope of the regulation and you are compliant, the most straightforward way to prove that to us is by providing the internationally recognized certificate of compliance, or the IRCC. The thing with the IRCC, though, which Francis mentioned a few slides ago, is that it is voluntary for the provider country to provide that and upload it to the ABS clearinghouse. So you may not always have the IRCC available, which is perfectly fine. And instead, you might have the prior informed consent, which is the permit, and you might have the mutually agreed terms, which is the benefit sharing agreement or contract. And either of those, or the combination of those together, or equivalent documentation, can prove your compliance with the ABS regulations. If, however, you consider your project to be out of scope of the ABS regulation, then the type of evidence that would be needed will vary depending on the reason why you consider your project to be out of scope. So, for example, if a project is out of scope because the genetic resources were accessed long before the Nagoya Protocol came into force, so for example, perhaps they were accessed in the year 1990, evidence to prove that date of access would be needed to prove that the project is out of scope. And that could be something like the receipts, it could be the postage documents, it could be the material transfer agreement which accompanied the material, or it could be the research proposal. If, however, you have a project which you consider to be out of scope for another reason, so for example, because the type of work is not considered utilization, it's not considered as research and development into the genetic or biochemical composition, then the type of evidence will need to be different, and it will need to reflect the use of the genetic material. So for that scenario, something like a research proposal, again, the material transfer agreement, or something similar could be more applicable. We understand that this is a topic which can raise a few questions, and it does definitely vary depending on specific scenarios. So if you'd be interested in discussing that further, please do either pop a question in the chat box or raise your hand later or send us an email, and we'll be happy to chat about that with you. So next slide, please. Okay, so this slide here is just a slightly different topic to what we've mentioned in the last few slides, but something which is no doubt of interest to many of you, which is regarding the public health emergency scenarios under the ABS regulation. So the Nagoya Protocol explicitly recognises the importance of genetic resources to public health. The ABS regulation gives special status to a pathogenic organism that's determined to be, or is determined likely to be, the causing pathogen of a present or imminent public health emergency of international concern or of serious cross-border threat to health. So users who acquire and intend to utilise genetic resources such as these, which are in scope of the UK ABS regulation, are entitled to an extended deadline for compliance with due diligence obligations. So users should fulfill these obligations either 1 month after the imminent or present threat to public health is terminated, or 3 months after commencement of utilisation of the genetic resource. So whichever of those dates is the earlier. Next slide, please. So for the next few slides, we've included a few examples of challenges that we've noticed users experiencing over the last few months, which we just thought could be useful for you to hear about, perhaps in case you're experiencing something similar, or in case it helps you to avoid the challenge in the future. So one question that we do hear relatively often is who actually is considered as the user of a genetic resource. So users can be considered as either individuals, they could be considered as the organisation, or they could be considered as both the individual and the organisation responsible for the research and development on a genetic resource. It does depend on a case-by-case basis, so unfortunately it's not something we can give a very clear answer to without looking at your specific scenario. But it's important that both the individuals and the organisations consider that question, because any cases of non-compliance can have reputational repercussions for both entities. It's also worth pointing out here that service providers are not considered as users. So there are cases where users of genetic resources perhaps work with a service provider to conduct a specific aspect of the research on a genetic resource. But in those cases, the user is still the one who's responsible for the project, and they are still the ones who are required to fulfill the ABS obligations. It's not the service provider. Next slide, please. Thank you. So another point that we've noticed is that when we get in touch with organisations, they sometimes don't have a central list of projects of all of their genetic resources readily to hand. It's not a legal requirement to have this central list of projects, but it is something which does promote compliance, and it is something that we would recommend you consider. In order to set up this central list of projects, it can be useful to implement internal guidance or procedures for identifying projects with potential to be in scope of the regulation. And it's also useful to set up a centralised system or database to store relevant evidence and information associated with those projects. So we understand that it can take some time and effort to implement these things and to set up. But by discussing this and experience with organisations who have done this previously, we do see that it is something that does save time in the long run. So it can be a good idea to consider. Next slide, please. Great, thank you. So when you all registered for this webinar, there was the option for you to submit questions. A lot of the questions were related to compliance with the regulation and our approach towards enforcement. So hopefully we've covered that already so far. If not, that's not a problem. Please do again add your question to the chat or raise your hand in a few moments' time. But there are 3 questions which we thought were particularly interesting and which may be useful for us to discuss in a little bit more detail. So the first question here is, what is the difference between non-profit and for-profit entities with respect to ABS compliance? So this question is quite straightforward. The answer really is if a project is in scope, all UK users of genetic resources must comply with obligations of the UK ABS regulation, regardless of whether they are for-profit or non-profit entities. So the status of an entity being for-profit or not-for-profit doesn't make a difference with regard to their ABS obligations. In the second question here, this question is related to intermediaries. So it says, for genetic resources that are obtained by intermediaries, What is the appropriate standard of due diligence for compliance with the law in the UK? This is not a rare scenario, so it is a good one for us to touch on. And basically, if genetic resources are obtained from intermediaries, it is the responsibility of the user, firstly, to determine whether their project or their intended use is in scope of the UK ABS regulation and also in scope of the provider country's ABS measures or not. If it is in scope of the UK ABS regulation, then the user must ensure that the appropriate prior informed consent, mutually agreed terms or equivalent documentation are in place for their intended use before they start utilising. If they are obtaining these genetic resources from the intermediary together with the PIC and MAT or equivalent documentation, it is also the user's responsibility to ensure that their intended use is covered by that pre-existing PIC and MAT. And it may also be that they need to get back in touch with the provider country authorities and renegotiate the PIC, MAT and equivalent if necessary. You'll need evidence to prove compliance or to prove that your project is out of scope. The intermediary may be able to help by providing some information if they have it or some evidence, or they may also be able to point you in the direction of where that evidence can be found. But ultimately, responsibility for complying and for exercising due diligence rests with the user, not with the intermediary. So the third question here is asking what arrangements apply to genetic resources under sovereign rights of a country which is not party to the Nagoya Protocol when these are provided to a UK-based service provider for use in contract service provision. This question, I think, can really be split into two separate questions. So firstly, what are the obligations on a user when the material is from a country which is not a party to the Nagoya Protocol? So I think we sort of briefly touched on this earlier, but if a genetic resource originates from a provider country which is not party to the Nagoya Protocol, then it's out of scope of the UK ABS regulation. And there are no obligations which apply to that user under the UK regulation. But it is still worth considering that that provider country may still have ABS legislation in place, which the user would need to comply with. Then I think the second part of this question is really around the roles and responsibilities between service providers and those requesting the work. So responsibility for compliance with the UK ABS regulation rests with the user. So the organisation requesting the work, which is presumably the organisation which accessed the genetic resource in the first instance before contacting the service provider, they would be considered the user and the obligations would rest with them. So if we have a scenario where there's a user in another country, so for example in France or South Africa, and they send genetic resources from that country to a service provider in the UK to utilise on the user's behalf, that scenario would likely be out of scope because the entity considered as the user would be located outside of the UK. It's still worth considering, though, that the service provider may want to kind of make sure that the correct paperwork and everything is in place with regards to the user, and that the user is complying before the service provider undertakes any research and development. So they might want to make sure that there's evidence regarding where the material comes from. Next slide, please. So finally, on this slide here, we have some resources which might be of use to you. We have a LinkedIn page for access and benefit sharing, which you're all very welcome to join. The intention of this group is to help or to enable people to remain up to date with relevant information, but it also provides a good kind of platform for UK users of genetic resources to ask each other questions and to share experiences. We also have our webpage, which is the second line down, which you're also welcome to take a look at, and that's where you'll find more information about how to submit due diligence declarations, or if you would like to register your best practice or apply for recognition of registered collections. You're also very welcome to send us any inquiries, any questions that you have to the OPSS inquiries email address here. And if you'd like to take a look at a previously recorded webinar, there is a session which we recorded in October last year, which you can also view on this YouTube link. If we move to the next slide. Thank you. Yeah, so that's the end of the slides that we have prepared for you today. And I can see that there's already been quite a few questions posted into the chat box, which is great. So I'll now take some time to look through those and see what you've asked.